Hello folks, welcome to the Edupedia world, and I am Abhinay Gupta. So today we'll start with a very interesting topic, which is the Banking Regulation Act 1949. It is very simple to remember the date. It is just 2 years after your independence. So the Banking Regulation Act 1949 enacted by the Parliament on 10th March 1949. That is when it came into existence, right? It was passed by Parliament somewhere in February 1949. Initially, this legislation came up to regulate the banking firms in the country. But later on, the law was applicable not only to the banking companies, but in somewhere around 1965, it was extended to the cooperative banks as well. And the Act provides a framework using which the commercial banks in India are supervised and regulated. This Act also supplements the Companies Act 1956. The basic provisions applicable on a company will be applicable on a banking company too. But the Banking Regulation Act goes a way ahead to supplement the Companies Act in giving out some more provisions in detail and specific, right, as to the applicability of the same on the banking companies. So this Act, this regulation, the Banking Regulation Act legislation, this gives the power to the Reserve Bank of India. It gives the immense power to control and govern all the banks in the country. It gives them the power to issue the license to the banking company, to operate as a banking company. So RBI is the supreme power when we consider the bank. RBI governs the members, the directors, like the appointment, the shareholding and everything. It also controls the mergers and acquisitions, lays down instructions for audit, for the performance of the bank, for the appointment of the board, etc. So if we conclude it in a nutshell, Reserve Bank of India is the supreme power, right? Whatever it says, the bank has to do. So this is the brief about, I think you get an idea about what Banking Regulation Act is all about. So let us move ahead and see the applicability of the Act. So basically the Act applies on all the nationalized banks, even on the non-nationalized banks and the cooperative banks, and that too in the manner and to the extent specified in Part 5. Now there's a confusion. What are nationalized banks and what are non-nationalized banks? So if you go back to the period, like 50 years back somewhere, when Indira Gandhi was in power, at that point the government had nationalized around 14 banks. Those banks were given the position nationwide, right? They were governed centrally. That was the time when 14 specific banks were recognized to be nationalized centrally, and then again somewhere around 1980 other 6 banks were nationalized. So these nationalized banks are covered by the Banking Regulation Act 1949, and even the banks that were left behind that were not nationalized but they're still banks, they're operating in the country, even those banks have to follow the provisions of Banking Regulation Act 1949. And as I've already discussed, in somewhere around 1965, the Act extended to cooperative banks too, right? Initially it was built, the legislation was built for only the banking firms in the country, but later on it extended to the cooperative banks too. So the cooperative banks, which operate only in one state, are formed as well as they are run by the central government. But still, the Act gives RBI the supreme power again. It gives them the control and the license, right? And RBI itself regulates the business of those banks too. Because that is, the cooperative banks have been included in the purview of the Act. Right? And so RBI will have the power to govern those banks too. So moving ahead, we'll try and understand meanings of some basic terminologies that will help you to understand the Act. When we read the text and when we explain the terms ahead, you will get an idea about what we are talking. Okay? There are some specific terminologies, like we'll be discussing what is banking, what is a banking company, what are loans, secured, unsecured, both. What are the parameters that will distinguish a small-scale industry from a large-scale industry? What do you mean by substantial interest in any firm or any company? Right? So these are basic things that you need to understand, because these are the terminologies that will be used widely in the chapter ahead. Right? So if we start with initial definition, actually the initial meaning of the term banking, then I would initially like to read out the text of what banking is. So as per the text, as per the Act, section 5 subsection B of the Act, banking means the accepting for the purpose of lending and investment of deposit of money from the public, repayable on demand or otherwise, and withdrawable by check, draft, order or otherwise. So this is the text of the Act. Right? Now if we go ahead to interpret it, right, there are 6 basic points that you need to remember. First thing is that banking means accepting. Now what do you accept? You accept the deposit of money, right? And who gives you the money? It is coming from the public. So banking means accepting money from the public. First thing, these are 3 points, right? Next is, why do you accept money? What do you do with the money? Right? So you accept it for the purpose of lending ahead to some other party, so third party, right? Like you borrow from somebody, then you lend it to somebody, and for making investments, right? And there are other functions also, that the money once deposited are repayable on the demand of the depositor, right? So they are repayable on the demand or by any other mode. Like if the tenure comes to an end, you'll have to refund the money. Like if you have prepared an FD with a bank for 2 years, then after 2 years, even if the person does not demand, the FD matures, right? And then it also gives the power to the depositor to withdraw the money from the bank whenever they need. So right, and there are various modes of withdrawing the money. It can be withdrawn by check, draft, order, or by any other mean, right? By using negotiable instrument or anything. So basically, if you club all these 6 points, you get the meaning of the term banking. So it is just one single word, but it has a depth behind it, and that is what you need to understand when you are learning a chapter. The chapter is on banking itself, right? It is an act for the banking. It is a banking regulation act. How do you regulate the banking in the country? So you need to basically know what banking is, right? So we'll again summarize the points. We'll club it together. So banking is when you accept the money from the public, right, for the purpose of lending and investment, and that can be withdrawable as well as repayable, right? And then the entire definition is what you have to remember if you get to quote it in the exam, but it is rarely asked in your exam, the direct quotation. But if you know all the 6 points, it will help you to frame your answers very well. And you can break them down into points and then frame your answer whenever you are answering any question about the banking chapter, because these are the points that will be common in any question asked in the banking from this chapter, right? And this is not a very lenient chapter. You have been asked marks from ranging from 4 to 8 in almost all your examinations, in almost all your attempts, right? So this is not a very light topic. It's easy, it is small, it is precise, but it is important, right? And if you consider your study material that is provided by the CA Institute, you have this chapter clubbed with SARFAESI, that is securitization and reconstruction of financial assets, right? Okay. So now you understood what banking is. Moving ahead, we'll try and understand what banking company is. If you go by the definition, right, it is just, the Act says that banking company is any company which transacts the business of the banking in India. And what is the business of banking? That we have already discussed, right? So any company which is into banking is a banking company. And so when we talk about the term banking, you need to understand that if you are a manufacturing or a trading entity, and then you accept money from the public, accept deposit from the public for the purpose of enhancing your manufacturing unit or to promote your trade or stuff, like for the investment in your own business, that is not considered as banking, because you're not accepting money for the purpose of lending or investment, and that money is not repayable by check, draft or otherwise. It is not withdrawable and it is not repayable on demand, right? So that is what you need to understand when you're talking about banking. It is banking. It is not simply accepting money from public, right? Now if you talk about loans, loans are basically of 2 types. Either they can be secured or you can even advance unsecured loans. So when we talk about unsecured loans, it is very simple. These are the loans that you advance to the other person without taking a security for the loan. You don't have an asset secured with you. whereas a secured loan is a loan made on the security of assets, right? And there is a specific requirement for the asset to qualify as a security, right? What is that requirement? It says that the market value of that asset at any time during the year or any time during the period of loan, right, should not be less than the amount of such loan, right? So whatever security you give to the bank in exchange of the loan that you have taken, you will have to analyze the market value of that security, and that has to be more than the amount you take as loan, and that has to be constant. That always has to be more than the value of loan throughout the period of loan, right? Moving ahead, we have the small scale industries. Now, small scale industries have been given a bandwidth. They have been given a ceiling and a limit below which, if you fall below that limit, you are a small scale industry. If you cross the limit, if you cross the boundary line, you are a large scale industry. Now, what is that limit? Right? So, if you go by the text again, then small scale industrial concern means an industrial concern in which the investment in plant and machinery is not in excess of 7.5 lakhs or such higher amount not exceeding 20 lakhs. Like 20 lakhs is the higher limit. Right? As CG may, by notification in the official gazette, specify in this behalf, having regards to the trend in the industrial development and other relevant factors. Which means to say that on a general term, like if you draw a general line of difference, it is the investment in plant and machinery. If it is less than 7.5 lakhs, it is a small scale industry. If it crosses 7.5 lakh, it is a large scale industry. Right? The text says not in excess of 7.5 lakh, which means even if it is 7.5 lakh, it is a small scale industry. Now, there are some specific industry to which the CG may increase the limit of 7.5 to any amount between 7.5 to 20 lakhs. Maybe 15 lakhs, 18 lakhs or whatever, depending on the industry and depending on the CG, whatever it deems fit, right? And how will it do that? It will give out a notification in the official gazette, right? And that will be applicable. So that is all about small scale industry. Just remember the bandwidth, remember the line, it is 7.5 lakh. Investment in plant and machinery, to be very specific. It is not the overall investment. Now we need to understand what substantial interest is. So again, going by the text, substantial interest in relation to the company means the holding of a beneficial interest by an individual or his spouse or minor child, whether singly or taken together, in the share thereof, the amount paid on which exceeds rupees 5 lakh or 10% of the paid up share capital of the company, whichever is less. So what do you understand by this? Right? What do you understand by substantial interest now? So you will be considered to be holding a substantial interest in any company if you have made an investment of more than rupees 5 lakh in that company. It is as simple as that. Like if you have purchased the share of a company of total value of more than 5 lakh, you will always be considered to be substantially interested. That may be taken up by you on your own name or on the name of your spouse or your minor child. It will be clubbed for this purpose, right? Now, what does that mean? That if you are below 5 lakh, you will always be considered to be not substantially interested? The answer is no, because there is another limit which says that if you are investing more than 10% of the paid up capital of the company, you will be considered to be substantially interested. So if a company has a paid up share capital of 10 lakhs, right, if it is only rupees 10 lakh, then what is 10% of 10 lakh? It is just rupees 1 lakh. So if you are investing 1.2 lakh, 1.5, 3, 4 lakh, 2 lakhs, whatever, you will be considered to be substantially interested, although you are below the limit of 5 lakhs. Because the act says it is rupees 5 lakh or 10% of the paid up capital of the company, whichever is less. Right? So that is the interpretation that we'll take from that. Right? But this is only in the case of company. When we consider the case of a firm, the limit of 5 lakh does not exist. That is the only simple difference. So they are very straightforward with it, that if you are investing more than 10% of the total paid up share capital of my company, you will be considered to be substantially interested in my company. It is a simple term, right? So these were the basic definition that we had to understand to move ahead with the chapter. It gives you a better understanding of the chapter, right? So with this, like, these were the basic 5 terminologies that I wanted to share. We'll move ahead with the section 7, which says prohibition on the use of the word bank, banker, or the banking company. So what does this mean? This means that if you are into the business of banking, like what we talked about a banking company is a company which is into the business of banking, right? So if a company is into the business of banking, it is a compulsion for that company to use any of the above terms, which is either use a bank, banker, or a banking company. And on the other hand, all the companies who are not into the business of banking are prohibited from using these words. They will not be allowed to use the word bank, banker, or the banking company. If they do, they will be liable to penalties, right? The same thing applies to the firms as well. No firm will be allowed to use the word bank, banker, or banking company, other than if they are transacting the business of banking. But there's one more point to remember, that these restrictions do not prevail on the associations of bank. So what are the associations of bank? Associations of banks are basically formed for the protection of the mutual interest. Right? The banks, they come forward, they prepare an association among themselves, that is to conserve the mutual interest. Right? Okay, if we do this, we come out with an agreement, right? And that will be beneficial to all of us. Right? And also the registered company, registered under section 25, that is the licensed company, right? Even they are considered in the same genre. So that was all about section 7. Now we move on to the next section, section 9. Now what has section 9 got to tell us? Section 9 deals with the disposal of the non-banking assets. So there is a limit drawn beyond which you cannot hold a non-banking asset. Like, now what is a non-banking asset? These are the assets which do not actually belong to the bank. The bank did not acquire this asset for the purpose of banking, for the purpose of enhancing its business. It's like, for example, its offices, its desks, furniture, laptops, computers, desktops, whatever it is. Right? These are the assets of the bank. They have acquired this asset, they have purchased it for operating their banking business. But for now, there's a land that was mortgaged with the bank, and since the borrower was not able to repay the loan, the bank took over the asset. Now this is a non-banking asset for the bank. It is not an asset that is required for your day-to-day operation. It is not an asset that facilitates your banking. It is an asset that you have acquired in the process of your banking activities. So these are non-banking assets, and these will have to be disposed of within a period of maximum 7 years. Like, if you have a land taken away from somebody, you can hold it for 3 years, 4 years, 5 years, but keep looking for deals. Whenever you get a good deal, just dispose it off. Right? And that period till which you will wait should not exceed 7 years. Right? But RBI has the power to extend the limit, the periodical limit, the limit of 7 years. So if they approach RBI for giving them an extension for any major asset that they don't want to dispose, or they're not getting a good value, they still prefer that, okay, if you are given a year or two, maybe we'll get a good value and we'll dispose it off. So RBI can give you a maximum extension of 5 years. If you require an extension of 2 years, it will give you for 2 years, 3 years, but the maximum limit available with RBI also is 5 years. So RBI is bound by the act over here. Right? So 7 plus 5, 12 years is the maximum period you can keep an asset, non-banking asset, with yourself, and then you will have to dispose it off. Right? So far we have covered the definition, section 7, section 9. We'll wind up the class over here today, and we'll pick up the next sections and go with the flow of the chapter in the coming lecture. So until then, this is Abhinay Gupta signing off. Stay tuned for the next lecture. Thank you.